The jury is one of those important measures that we have thought so important that it was entrenched in our Constitution in 1982 by way of Section 11F, such that every individual prosecuted of a crime, which may be punishable by 5 years in jail or more, has the option to elect to be tried by 12 randomly selected citizens to ensure that justice is carried out according to their fellow countrymen.
That we forget about it and rely on everybody else to do it, but it's people that can hold them to account. Accountability is what's the main thing here that's lacking in our society.
So we have a federal government that took it upon themselves to implement and use the highest powers available to any government in this country by invoking the Act and suppressing the rights, the charter rights, constitutional rights of Canadians on information that was false.
A publication ban has been applied upon the proceedings in the trial of the Coutts three, Alex Van Herk, George Jansen, and Marco Van Hugenbos, three men charged with mischief for their involvement in the Coutts blockade of 2022. Robert Kraychik here reporting for Rebel News in Lethbridge, Alberta, outside its courthouse. The Coutts blockade was a peaceful demonstration obstructing traffic across the U.S.-Canada border located in Coutts, Alberta, between Alberta and Montana. It occurred around the same time as the Freedom Convoy demonstration in Ottawa, Ontario, and both shared the same goal. They were opposed to orders, edicts, decrees, mandates issued by various levels of government as part of what I refer to as the COVID-19 enterprise, ostensibly for the purpose of so-called public health in response to COVID-19. Now, folks, please remember that we need your financial support to fund this sort of in-the-field journalism. On my part, I came in from Ottawa, so you guys can chip in to assist in my economy airfare, my economy accommodation to help us keep doing this. And you can also contribute to the defense fund for the three defendants. And if you do so, you'll be issued a charitable receipt by the Democracy Fund, which is administering this fundraising effort. So please visit Coutts3.com and help us as you can. Since the proceedings of this trial, which began last week, are under a publication ban issued by the judge, we cannot disclose what's going on inside the courtroom. But what we can do, which is still of interest and value to the Dear Rebel News audience, is speak in broad terms about certain mechanics that are relevant to this case. Specifically, we can discuss at some point publication bans, and I was fortunate enough to speak with one of the defense lawyers, Michael Johnston, who explained the importance of juries in the context of Western criminal justice. So, Michael, why don't you talk to us about why juries are important and how they might be a sort of bulwark against tyranny or centralized government control?
I mean, it's a very involved question. I'm not sure how easy it is to reduce to a couple of sound bites, but I think in fairness, for a long period of time, juries have existed, as you've said, in their conceptualization as a bulwark against the oppressive machinations of the government, because 12 individuals are randomly selected from society and brought forward in order to render a general verdict. And in rendering a general verdict, 12 ordinary, randomly selected individuals determine, according to the facts and the law as it is given to them by their judge and by their conscience, what will ultimately be just in their communities and in society at large. So historically, since 1670, one of the famous cases in jury law is the case of William Penn and William Meade, who were prosecuted for unlawful assembly pursuant to, I think it was then the Conventicle Act that forbade more than 5 people publicly gathering, and so they were prosecuted for this. They were Quakers, and they were meeting for religious purposes, and ultimately the jury that was determining their case refused to convict them despite the suggestions by the trial judge that they should do so. The jury was ultimately imprisoned and fined because they refused to find the individuals guilty, though it appeared as if the facts and the law allowed of no other course. And subsequent to that, there is what's known as a Bushell's case, which decided that juries could not be punished or fined for acting in accordance with their conscience. There's certainly been a lot of other jury decisions that are notable in the United States or in the American colonies before the Revolution. There was the case of John Peter Zenger. In Canada in 1835, there was famously the case of Joseph Howe, who had published some things that were critical of the local constabulary and the local judiciary. And at the time, publishing libels did not allow, for example, for truth to be a defense. And in his defense, when he represented himself before the jury, he functionally said that what he had published was true, and he was simply seeking to be critical of the local government. And given the problems that therein existed, he had no other option but to publish these things. And the jury in that case famously refused to convict him. Dr. Henry Morgentaler is one of the classic Canadian examples of where a jury, several juries functionally refused to convict Dr. Morgentaler, where his actions could be said to have violated factually what the law was then with respect to the provision of abortion services. And though the law would have required him to also be found guilty, juries didn't convict in that case. And so you have some examples, for example, largely hundreds of years ago, people gathering in violations of certain laws or the publications of what was then seditious libels that didn't provide truth as a defense, or other actions that ultimately society might not be in agreement with, though the laws that have been passed on their behalf seem to suggest are problematic. So the jury injects, importantly, a public conscience into the prosecution of laws, because of course we elect individuals, and the individuals act as our expedients to pass laws and help organize society. But at the back end, when those laws are being applied to certain scenarios and factual sets of circumstances, ordinary people are brought back into the equation to determine if what is happening is truly in conformity with what they wish to have happen. So in some ways, trial by jury remains an important affirmation of the notion of popular sovereignty. I know that Frederick Douglass, the famous American thinker, talking on the subject of slavery, once said that individual rights are importantly predicated on three boxes: the ballot box, the jury box, and the cartridge box. And the jury is one of those important measures that we have thought so important that it was entrenched in our Constitution in 1982 by way of Section 11F, such that every individual prosecuted of a crime, which may be punishable by 5 years in jail or more, has the option to elect to be tried by 12 randomly selected citizens to ensure that justice is carried out according to their fellow countrymen.
I was also fortunate enough to speak with two of the defendants, Marco von Hugenboss and also Alex Van Herk. The former reflected on the final days of the Coutts blockade and addressed certain misunderstandings regarding the application of the Emergencies Act by Prime Minister Justin Trudeau in relation to the Coutts blockade. Specifically, he explained that while the Coutts blockade was used as a pretext or rationale for the invocation of the Emergencies Act, the powers given by the Emergencies Act were not used to end the Coutts blockade. Now, the latter, Alex Van Herk, reflected on what he sort of described as a political and philosophical awakening that occurred within him and many that he knew as a function of the abuses and coercion of the COVID-19 enterprise. And Alex, I want you to speak to the audience about how the time that I described as the COVID-19 enterprise led to a sort of political, philosophical evolution or development for yourself and people that you knew. Did you see people's minds being opened or changed based on what they were experiencing and dealing with?
Oh, definitely. I feel COVID was an awakening for a lot of people. The suppression, I feel people felt that there was something wrong, and they knew that with the suppression of what was happening, that the only way they can change it is by standing up and getting vocal about it and getting involved. I look at what transpired after Coutts. I mean, the whole political movement in Alberta with Jason Kenney and getting him ousted out of his as premier, and the Take Back Alberta movement that started up. So there was a big movement in our community and in our friend circle that got involved in the political world of it, and to this day are still involved and have realized that, yes, people can make change, but you have to be involved. You have to take part, whether it's in a municipal level or even in a town council, libraries, any school boards, anything that you can get involved in to make change, because the wokeness of the left-leaning people, they have all the time, it seems like, to be involved, and we're too busy working and taking care of our families and doing things that we forget about it and rely on everybody else to do it. But it's people that can hold them to account. Accountability is what's the main thing here that's lacking in our society.
So I'm here with Marco, one of the defendants here this week. Marco, would you share some information with our audience about the timeline leading up to the conclusion of the Coutts blockade and things that might be of interest to the audience in regards to that?
Yeah, so the public perception out there is that the EA, the Emergencies Act, was invoked, and that led to the resolution of the Coutts blockade, and that's a false narrative. The Coutts blockade was peacefully resolved. The protesters down there, after the arrests that happened in the evening of the February the 13th, leading into the morning of the 14th, decided that what the objectives they were looking to achieve were no longer possible due to the false narrative that the legacy media had spun at that time. At that time we didn't know what was right and what was the truth, and the fact that that was a false narrative that has since come out over the last year and a half, 2 years. But on the morning of the 14th, we members of the protest worked with the RCMP to come to an agreement that would involve the blockade being lifted immediately, and the protesters being allowed or having the official approval to stay in the capacity lawfully at that location to leave the morning at 9 o'clock the morning of the 15th, and in leaving behind nothing other than a possible oil stain on the middle of the highway. So the Coutts blockade and the events of the evening of the 13th and the morning of the 14th were a big factor in Ottawa as a reason to invoke the Emergencies Act, but the authority given the government under the legislation of the Act was never used in Coutts. The information that the Alberta government and the RCMP used during the POEC was that the Coutts blockade was resolved, and that was something they did. But the real story is that protesters decided to leave peacefully, as peacefully as they had been there for those 18 days, the duration of those 18 days. And that's exactly what happened at 9:45 the morning of the 15th.
If I would have spoken to you, let's say 5 or 10 years ago, or these people in your familial or friendship or professional circles 5 or 10 years ago, would you say there was perhaps a different perspective or a lower level of awareness of these things about which you're discussing?
Oh, 100%. I think even myself 5 years ago, I mean, I guess we lived through an era, was probably one of the freest eras in society. The 70s and 80s were the best. I mean, we could carry rifles in our back window, and I mean, we were able to do anything, leave your keys in your vehicle. So we lived in a pretty free society through them years. It's the 2000s is kind of where I started seeing some change. And then the slower to change, but we were still quite free. But it was COVID that really suppressed people and woke people up as to what was happening. And probably the biggest thing what changed was the mandating of these, when they started mandating these vaccines, is what really made change in Alberta. And when most people, your bodily autonomy is up to you, to your choice. And when they started mandating that, and I've seen a lot of people, that's what drove the whole convoy to Ottawa, was when the truckers were good enough to haul all the products and they couldn't go into restaurants or nothing for 2 years. And then all of a sudden the truckers weren't allowed to go anywhere unless they were vaccinated. That's when I said the tyranny of it, the what's the right word?
Oppression, control?
Yeah, the control of it. It's like, okay, there's a different agenda behind this. And I think a lot of people saw that and said there's more behind it than just the COVID. And I think that's what woke a lot of people up. So definitely the change, I felt COVID really made a change in people to wake up and stand up.
So just to make sure I understand this clearly, to summarize things, the Coutts blockade was not ended via the Emergencies Act powers, yet the Coutts blockade was used by the government as a pretext for invocation of the Emergencies Act. And that there's this perception out there, I think myself included, I'm guilty of that. I thought the Emergencies Act itself was used to empower police to end the Coutts blockade, but that wasn't the case.
No, Ottawa needed a good reason to invoke the act, right? It's the highest legislative power available to any government in this country, and they needed serious reasons to invoke the act, and the scenario and the details that came out of the Coutts blockade were in their mind serious enough, even though the recent Mosley decision determined that the government was unjustified in their invocation in invoking the Emergencies Act. But like you just asked, that is correct. The resolution of the Coutts blockade was a decision made by protesters in corroboration with the RCMP, and the Emergencies Act and the implementation of the Act, and even the rumors of the Act being discussed, that didn't matter to us. You got to remember, this is Alberta, and no disrespect to Ottawa, but Alberta isn't really overly fond of Ottawa, and what Ottawa wants, what Ottawa thinks, doesn't really have an effect in Alberta. So while being respectful, we frankly didn't give a shit what Ottawa wanted and what they thought at that time.
What we were discussing earlier regarding the photographic evidence of firearms versus the claims made by police to, again, justify the Emergencies Act invocation. Can you share some information with our audience regarding a discrepancy of timeline?
Yeah, so now more than 2 years after the blockades and the protests, there is now sworn evidence that states that the RCMP had no physical, visual, or factual evidence of firearms until the search warrants were executed on the morning of the 14th, Western Standard Time, or sorry, Mountain Standard Time, so Alberta time. So we're in the 14th, so let's just stick to dates here. What we also know, due to the testimony given by cabinet ministers, bureaucrats, and even the Prime Minister's office during the POEC, was that on the 13th of February 2022, previous Commissioner Brenda Lucki informed previous Emergency Management Minister Marco Mendicino that the volatile situation in Coutts was due to firearms, weapons, guns, and that this was up until now, the most serious situation of the protests and blockades across the country. This was things were escalating, and they used the information that they had received at that time of firearms, weapons, and guns at Coutts on the 13th. We now have testimony that until the search warrants were executed on the 14th, there was no visible, factual, or physical proof of firearms. So we now have evidence, the public now has evidence, sworn testimony that Ottawa, that previous Commissioner Lucki, previous Emergency Management Minister Mark Racino, previous or current Chief of Staff Katie Telford, and the Prime Minister himself on the 13th, during the IRG, the Incident Response Group, leading into a cabinet meeting, which then led to a first minister's meeting and then a caucus meeting, was based on false information. We not only have court rulings, federal court rulings that rule the implementation and the execution of the act as unconstitutional. We now have the grounds that the justification was based on by this government fall away. So never mind a government who feels they have the authority to invoke a legislation that is available to them. We now know that the information they used and that the reasons and the evidence that they said they had, this wasn't rumor. They didn't say there's speculation or there's rumor or there's hearsay. No, this was factual. This was information relayed to officials in the highest levels of power in this country. And we now know that this evidence was false. This information was false. So we have a federal government that took it upon themselves to implement and use the highest powers available to any government in this country by invoking the Act and suppressing the rights, the charter rights, constitutional rights of Canadians on information that was false.
So Michael, you made some remarks earlier about juries sort of being subsidiary institutions downstream of democracy. Use the term a little parliament. Can you just elaborate on that? Because I thought that was great. It sort of captures the function, the importance of juries.
Oh well, I was simply echoing the famous quote of a British judge, Lord Devlin, who, in giving some lectures in 1959, known as the Hamlin Lectures, likened every jury to a little parliament and suggested that the jury sense is much like the parliamentary sense, and that he couldn't see one surviving if the other one died. And I believe I've already made some remarks that suggest that by involving individuals, the common people that we all are, in the actions of the government at the front end, at the back end, we ensure that what is actually happening on our behalf is at all times kind of in conformity with what the people wish, because governments are not instituted for the purposes of being bodies upon themselves. They exist in order to facilitate and to benefit us, the individuals. So in terms of the idea that Parliament is ultimately constituted based on the election of individuals, and then decisions are made by that body, similarly trial by jury is constituted by a number of individuals that are randomly selected, and they're entrusted with making decisions that create a check and balance on the powers of the government. And at times we talk about there being an important democratic dialogue that exists between the judiciary and Parliament, and so oftentimes we hope that the decisions that are made by the court or that emanate from the jury box can be heard by Parliament, and that informs how they legislate, because we're not seeking to conflict with one another, but hoping that laws are, as I think I've said, in conformity with the wishes of the people to whom ultimately the government should be responding.
Now, folks, please remember that we need your financial support to fund this sort of in-the-field journalism. On my part, I came in from Ottawa, so you guys can chip in to assist in my economy airfare, my economy accommodation, to help us keep doing this. And you can also contribute to the defense fund for the 3 defendants. And if you do so, you'll be issued a charitable receipt by the Democracy Fund, which is administering this fundraising effort. So please visit Coutts3.com and help us as you can.